Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision from a trial court. This is the United States District Court for the Southern District of New York in the case of United States of America versus Joshua Adam Schultz. In this case, we have an Edward Snowden-like situation. We have a person who is working for the intelligence branch of the government, in this case the CIA, and he released information to Wikileaks. He is being sent to jail, and he is arguing the statutes in play are unconstitutional as applied to him. Here, the district court is determining whether or not that's true. He's moving to dismiss several counts of the indictment, arguing that they shouldn't apply to him, so the district court has to decide. Will these indictments go forward? Are these counts valid? Is this person responsible for this? So it can go to a trial. Let's get started with that. The defendant, a former CIA employee, has been indicted for stealing national defense information and transmitting it to Wikileaks. At the CIA, Schultz worked with the Center for Cyber Intelligence Engineering Development Group. Schultz had a security clearance and he participated in training on different types of classified information and proper handling of the material. While employed by the CIA, Schultz signed a non-disclosure agreement in connection with his access to classified information. This is very typical. The government alleges that in the spring of 2016, Schultz, while working for the CIA, accessed certain CIA systems without permission and stole repositories of CIA cyber tools and source code, which he transmitted to Wikileaks. The second indictment charges Schultz with, among other things, 4 counts of violating one part of law and 1 count of violating a different part of law. Counts 1 through 3 charge Schultz with stealing information and transmitting it to WikiLeaks. Count 4 also charges Schultz under the law for retaining portions of classified information and other national defense information maintained by the CIA and disclosing it, or attempting to disclose it, to third parties not entitled to receive it. And Count 6 charges Schultz with theft of government property. Defendant now moves to dismiss Counts 1 through 4 and Count 6, arguing that the statutes are unconstitutionally overbroad and vague. So we're still in the middle of the trial, and he's trying to get some of these counts dismissed against him because he says they're unconstitutional and vague. I can tell you right now, no, they're not. This is not the first time we've had this issue. This is not the first time we've had this problem, and no, this is perfectly reasonable. This is well understood statute, and we're going to get into why in about a minute. Schultz contends that the Section 793 is unconstitutionally overbroad. He argues that the section amounts to a content-based restriction on the right of free speech that cannot survive strict scrutiny. It can survive strict scrutiny, I'm telling you right now. It's a compelling interest, and it is the least restrictive means. It can meet strict scrutiny, no problem. Normally very, very hard, but here, no problem. A law is unconstitutionally overbroad if it punishes a substantial amount of protected speech judged in relation to its plainly legitimate speech. Because finding a statute overbroad invalidates all enforcement, courts employ it with hesitation and only as a last resort. Overbreadth challenges present an exception to the general rule against third-party standing. The Supreme Court has made clear that not all categories of speech are protected by the First Amendment. Speech integral to criminal conduct, for example, is an area in which the First Amendment has permitted restrictions upon the conduct of speech. Yes, so like if as part of your criminal misdeeds, you are communicating with your fellow people, like let's rob the bank now, or let's shoot this guy, or whatever the case might be, that speech is not protected by the First Amendment. It is part and parcel of your criminal conduct. So yes, if your speech can be criminal when it's part of the criminal enterprise. So yeah, that's not a First Amendment violation. It wouldn't make sense if it was. Same thing with true threats for that matter. Conceding that Section 793 does not affect his constitutional rights, Schultz invokes the overbreadth challenge. The thrust of defendant's argument is the statutory phrases related to national defense and reason to believe the information could be used to injure the United States or the advantage of a foreign nation are so expansive, if applied literally, could allow the government to prosecute members of the media for obtaining and publish truthful information about U.S. foreign policy. The first step in an overbreadth analysis is to construe the challenged statutes. It's impossible to determine whether a statute reaches too far without knowing what the statute covers. This statute's sweep is apparent. It criminalizes theft and disclosure of national defense information by those who act willfully or with requisite purpose and intent or reason to believe the information could be used to injure the United States or advantage a foreign nation. There is no doubt the government's interest in national security is compelling, and the measures protected in the secrecy are plainly serve those interests. So we pass strict scrutiny. Yeah, no problem. This is compelling. This is least restrictive means. No problem. We're there. In furtherance of those legitimate interests, the statute focuses on illicit activity that injures the United States, and when a defendant takes, with a requisite culpable mental state, the defendant's overbreadth challenge is defeated by that mental state requirement within the statute. The statute prohibits copying, taking, making, or obtaining materials connected with the national defense, and only when the defendant did so with the purpose of obtaining information respecting the national defense with intent or reason to believe that that information is to be used to injure the United States or advantage a foreign nation. So you have to have a knowledge and understanding that you're doing this with this goal in mind. This is your intent. It is your hope for result. The section punishes only those people who transmit information related to national defense in tangible or intangible form to one not entitled to receive it. Importantly, the statute requires the government to prove the defendant willfully retained the information or disclosed it to an unauthorized recipient of national disclosure information. Absent from this record is evidence showing a substantial number of prosecutions for the media for obtaining and publishing truthful information about U.S. foreign policy as proposed under defendant's reading of the statute. Defendant's hypothetical examples under his reading of the statute fails. I would like to take note here that in one of the recent indictments regarding the Snowden issue, if memory serves correctly, that they did try to indict the media for something related to this, which I found went too far. So, there's at least some interest in this, but I think ultimately the media is going to get off the hook for anything related to the Espionage Act. So, almost anything. I think with respect to like what Snowden did, I think they're probably in the clear. But yeah, I think they were indicted or something at one point and I did not approve. So yeah, there's that. Nothing in the First Amendment confers on a government official permission to violate the law in the name of disseminating news. Very true. By virtue of his security clearance, defendant was entrusted with access to classified national security information and had a duty not to steal and disclose the information. He cannot use the First Amendment to cloak the breach of that duty. Turning to the issue of vagueness, he argues it's unconstitutionally vague. He raises as applied and a facial challenge. He takes particular issue with the clauses relating to national defense, willfully, persons not entitled to receive national defense information, and unauthorized possession. I don't really have a problem understanding any of those terms, and I'm not in this field. Unauthorized person seems pretty clear. National defense information seems pretty clear. I'm not having a lot of problems interpreting these terms personally. As discussed further below, courts have uniformly held judicial gloss on these causes provides sufficient note of what is criminalized. A statute is unconstitutionally vague if it fails to provide a person of ordinary intelligence fair notice of what is prohibited, or is so standardless that authorizes or encourages seriously discriminatory enforcement, but perfect clarity and precise guidance has never been required. The vagueness claim is particularly unpersuasive given the conduct at issue and the content of the documents he's alleged to have stolen and transmitted. Significantly, Schulte acknowledges that the Espionage Act may apply to him. Accordingly, the as-applied preference applies to this motion. This alone is fatal to the claim. The Supreme Court has found the phrase relating to the national defense to be sufficiently definitive to apprise the public of prohibited activities and consonant with due process, particularly when that information is classified. It's classified, so that, was a big clue. The Supreme Court interpreted willfulness and held that in order to establish willfulness, the government must prove the defendant acted with knowledge this conduct was unlawful. So you actually have to prove knowledge of the law itself, which is not normally required, incidentally. But this is one of those things. You have to show specific knowledge of the law you're violating. Okay. Defendant also argues the statute is unconstitutionally vague because it does not specify persons not entitled to receive information and unauthorized possession. Courts interpreting similar language have generally construed the statute with applicable restrictions on disclosure of protected information. Yeah, persons not entitled to receive is not really vague. If it's classified, the people entitled to receive it are people that have that classification status and with a need to know that stuff. So, Wikileaks is none of those things. So I don't find it particularly hard to interpret this, no. Martin, you are correct. Ignorance of the law is no excuse. There are some exceptions to it, though. There are some exceptions. And apparently this is one of them. So like all good rules in law, there's very little that's absolute. Apparently here, ignorance is an excuse. Okay, it happens sometimes. Statutes can be written to require specific knowledge of the violation of the statute, so yeah. And as the district court has explained, the phrase not entitled to receive is not at all vague when discussed in reference to the classification system, which clearly sets out who is entitled to receive. Those with proper security clearances and need to know, which is, what I said. And defendant was clearly aware of the prescripts of the classification system because he had actual knowledge and actual training on it. Yeah. Every court that has considered the constitutionality of the sections has rejected the claims as overbroad and vague. Yeah, not really happening, no. Defendant cites no case to the contrary, and accordingly the claim fails. The Second Circuit has determined Section 641 requires requisite notice and clarity when the disclosure at issue was affirmatively prohibited by statute, regulation, or policy, or longstanding agency practice. In other words, we have to tell you that this stuff is not to be disclosed. We have to tell you. We're not trying to trick you into this. So if we hand you a file and we don't say it's classified, then that we don't expect you to treat it in a classified way, right? We have to put you on notice. And they say here, given the government's longstanding practice of maintaining confidentiality of information relating to, in that case, ongoing criminal investigations, and given the government's obvious interest in maintaining confidentiality, the defendant could reasonably be known the prescribed nature of the actions. Also here, because the classified files, as I understand them, they have a cover on them that's color-coded that tells you just how classified they are. So and they're marked on every page because I've seen them with the markings after they're made non-classified. They're stamped. It's telling you that it's classified, and it's in the memos and all that good stuff too. So yeah, you kind of knew that the stuff was classified, and you kind of knew about the classification system and stuff like that, so not going to work for you. For the foregoing reasons, the court denies the defendant's motion to dismiss the counts of the indictment, and the clerk of court is directed to terminate the motion. So that is the end of the district court case of United States of America versus Joshua Adam Schulte. In this Edward Snowden-like case, we discussed that Joshua Schulte was a member of the CIA and had information regarding software tools the CIA used and gave those software tools and the underlying source code to Wikileaks, who is most decidedly not authorized to receive this information. He is currently being indicted for this, and he likes some of those counts against him struck because they're unduly overbroad and unduly vague. As we discussed, he's nowhere even near that standard. It's very clear what we're talking about is not really that difficult. You were specifically trained on the handling of classified information many times. You knew what you were doing. So it's no. You're falling well within the parameters of the statute. So nice try, but no. So go back to trial and let a jury figure out if you actually did these things and suffer the consequences. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.